welcome back. We will now, please take your seats. We will now begin the SIAC debate on the motion, this House believes that barbers and taxidermists are subject to far greater regulation than arbitrators. This motion is inspired from the writing of Mr. Richard C. Rubin. Arguing for the motion are Mr. Toby Landau, KC, Vice President, SIAC Court of Arbitration, and Ms. Pallavi Shroff, Managing Partner, Shardul Amarchand Mangaldas. Arguing against the motion are Dr. Abhishek Manu Singhvi, Senior Advocate, Supreme Court, third-term sitting Member of Parliament and former Additional Solicitor General of India, and Mr. Ritin Rai, Senior Advocate and Tenant at 7 Kings Bench Walk. This debate will be moderated by Mr. Bharat Chugh, Member YSIAC Committee and Advocate at the Chambers of Bharat Chugh, and Mr. Lomesh Nidumuri, Member YSIAC Committee and Partner at Shardul Amarchand Mangaldas. The judges for the debate are Justice Indu Malhotra, former Judge, Supreme Court of India, and Justice Badar Durraiz Ahmed, former Chief Justice of Jammu and Kashmir High Court and former Judge of the Delhi High Court. Bharat, Lomesh, please. Thank you.
Thank you very much. Now for the most exciting and interesting part of the day. I'm sure all of you are waiting for this very moment where you get to see the top legal minds of the country and retired Supreme Court judges participate in this really interesting topic. The topic, as my friend just mentioned, was this House believes that barbers and taxidermists are subject to far greater regulation than arbitrators. Now, just to give you a context of why we came up with this topic as part of the committee, we actually wanted to come up with something technology related, cryptocurrency, etc., but all that got shot down. We realized that if there is one area or one aspect of arbitration which is not so regulated today is perhaps the conduct of arbitrators. And that's a very debatable topic because there are two facets to it. One is, of course, you have party autonomy, where parties get the right to choose their own arbitrator and the arbitration process. At the same time, you have a larger notion of administration of justice to make sure that the quality of the judicial making, or rather the decision-making process before the arbitration also goes as per this thing. And the more I researched into it, I realized that our own scriptures, if you go back to Chanakya, Arthashastra, in fact, Arthashastra at page number 281, which I just read, has certain sanctions on judges for certain misconduct which was defined clearly in the scriptures. Now, this you're talking about in 3rd century BC. Now, one of them is asking the witness irrelevant questions, unreasonably delaying the case, and various other aspects. Now, the question is, we've obviously moved on from Arthashastra days. Gone are the kings, gone are the kingdoms. We have a lot more commerce in place today, and we have a lot more party autonomy in terms of deciding what should be the right way forward. So with this in mind, just to give you a broad context, we're going to have for and against. Now, the persons who are going to speak for the motion are going to argue that there needs to be more regulation insofar as arbitrators are concerned, and the persons who are going to speak against are going to say there is no need for regulation. So I will not speak further. I will just let my good friend Bharat take over now and introduce the speakers. Thank you very much.
Thank you. A very, very welcome, ladies and gentlemen. Today we have a stellar line of speakers today who need absolutely no introduction. We have arguing for the motion, Mr. Toby Landau, who's a King's Counsel, a Vice President of SIAC Court of Arbitration, a barrister and an advocate. Mr. Landau is a barrister and a member of the bars of England and Wales, Singapore, New York, BVI, and Northern Ireland. Toby has appeared in one of the most celebrated cases of arbitration of our times and is also one of the architects of the English Arbitration Act and many other arbitration laws across the world. He has argued hundreds of major international arbitration cases and investor state arbitrations. He's also the visiting professor at King's College London, Vice President of SIAC. In April 2012, he was appointed to the panel of advisors to the AG of Singapore. By his side and on his side is Ms. Pallavi Shroff, Managing Partner, Shardul Amarchand Mangaldas, with over 39 years of extensive experience. Her broad and varied representation of public and private corporations and other entities before various national courts, tribunals, and legal institutions has earned her national and international acclaim. Pallavi is the head of dispute resolution practice at the firm. She also mentors the competition law practice at the firm. Ms. Shroff is frequently featured by several international publications. She was also conferred the Lifetime Achievement Award at the Chambers India Awards in 2019. She has been recognized as one of the most powerful women in Indian business by Business Today and Fortune India. BW has recognized her as one of the most influential women in India for her exceptional contribution to the discipline of law. Now, arguing against the motion is an equally formidable team of rockstar fame. We have Dr. Abhishek Manu Singhvi, a senior advocate of the Supreme Court of India, third-term sitting member of Parliament, chairman Parliamentary Standing Committee on Commerce, and earlier on Law and Home, former Additional Solicitor General of India. Dr. Singhvi has the proud distinction of being India's youngest designated senior advocate at the age of 34 and India's youngest ASG at the age of 37. An eminent jurist and a front-ranking senior counsel at the Supreme Court, Dr. Singhvi is also a well-known author, a columnist, and senior-most serving national spokesperson of the Congress. Arguing alongside him and against the motion is Mr. Ritin Rai, who is a senior advocate and tenant 7 KBW. Ritin studied law at the CLC Delhi University, and before pursuing graduate law degrees at Oxford and at Harvard, he started his career as a transactional lawyer at Jones Day before returning to India to start his disputes practice. Designated as senior counsel by the Supreme Court in March 2019, his practice spans arbitration, commercial, and regulatory disputes. In addition to his arbitration practice, both as a counsel and as an arbitrator, Ritin regularly appears in the Supreme Court, the High Court, and the commercial tribunals in Delhi. Ritin is also enthusiastic about teaching and teaches a course of practice of commercial disputes at the Jindal Global Law School, where he is an honorary adjunct professor of law. With these being our two dream teams, let me quickly introduce the judges for today's debate, who again need no introduction and are people that we all look up to. We have judging the debate Justice Indu Malhotra, who is a former judge of the Supreme Court of India. Justice Indu Malhotra is a former judge. She is now practicing as a full-time arbitrator in international and domestic arbitrations. Prior to her elevation, she was practicing as a senior counsel in the Supreme Court of India and various high courts. In 2007, she was the second woman to be designated as a senior counsel by the Supreme Court after more than 3 decades. Subsequently, in 2018, she was the first woman to be directly elevated from the bar as a judge of the Supreme Court of India. Justice Indu Malhotra has specialized in the field of arbitration. Prior to her elevation, she appeared in various domestic and international commercial arbitrations. She has contributed significantly to the arbitration jurisprudence in India, both as a counsel and as a judge, and has authored significant judgments. In 2005, she was nominated by the Chief Justice of India in the category of eminent persons as a member of the General Council of the Gujarat National Law University. She is also a member of the Indian Law Institute and a member of the Academic Council of the National Law School of India University, Bangalore. Justice Malhotra has published the 4th edition of a commentary on the law of arbitration in India in March 2020. The commentary has been cited by various Supreme Court and High Courts in various judgments. We welcome you, ma'am. We also have Justice Badr Duraiz Ahmed co-judging the debate today. Justice Badr Duraiz Ahmed is a former Chief Justice of the Jammu and Kashmir High Court and a former judge of the Delhi High Court. Enrolled as an advocate in 1980 with the Bar Council of Delhi, Sir started his practice in the Supreme Court of India and Delhi High Court. Initially joined the chamber of Shri S.S. Ray, Bar at Law, for about 3 years. Thereafter, Sir practiced law independently. In 1986, he set up a law firm under the name of Lawyers Associated and was a partner with the firm till March 2000. Thereafter, he practiced in Supreme Court and the other high courts as counsel on various aspects of law. Sir also has a keen interest in personal laws and has written several articles in this connection and has also contributed to the section on deeds and other instruments for Halsbury's Laws of India. Elevated as a judge of the High Court of Delhi in December 2002, after 14 years as a judge of the High Court of Delhi, on 1st April 2017, Sir took the oath of office as Chief Justice of the High Court of J&K, which position he held till his retirement on the 15th of March 2018. During his entire tenure as a judge and Chief Justice, spanning well over 15 years, Sir was a prolific decision maker, having thousands of reported judgments to his credits across all branches of law: civil, criminal, commercial, taxation, environmental law, personal law, constitutional law. Sir has also been a member of the National Court Management Systems Committee and an invitee member of the Supreme Court E-Committee. He's actively interested in IT and computers and knows various programming languages. Sir has also written 2 standalone software packages for lawyers. Sir pioneered the introduction of paperless e-courts in the Delhi High Court, for which we're extremely grateful to Sir even today. Later in the J&K High Court, there he initiated the process of hearing court cases through video conferencing between Jammu and Srinagar and far-flung areas such as Kargil and Leh. He has and continues to advocate the use of technology in courtrooms and arbitration proceedings. Since his retirement as a Chief Justice, Sir has been and continues to be an arbitrator in several domestic and international arbitrations. He is and was Ombudsman of the Delhi and District Cricket Association. So with that stellar line of speakers, just to quickly also tell you the format of the debate, we'll have each of the speakers for and against the motion speak for about 9 minutes. So each speaker gets 9 minutes. First speaker for the motion and then against the motion. And thereafter, we'll have the 2 sides nominate 1 speaker each for a 5-minute rebuttal. And thereafter, we'll open the debate to the House and take comments and questions from the audience, which the speakers would have liberty to comment on for another 5 minutes before we hand it over to the judges for their verdict. So with that, let's quickly get started. May I request the honorable judges and the speakers to kindly join us on the dais. Thank you. So now the first speaker speaking for the motion, Mr. Landau. Yes.
Ladies and gentlemen, the scope for misconduct by barbers is readily apparent. Removing too much hair, removing the wrong hair, removing an eyebrow, removing an ear. The scope for misconduct by taxidermists is also readily apparent. Overstuffing, understuffing, stuffing the wrong pet, stuffing the wrong family member. There is no doubt that at international barber and taxidermist conferences, there must be frequent panels on recent developments in missing ears and overstuffing. But in each case, there exists a structure for full redress. Barbers have codes of conduct. Taxidermists have registration requirements and detailed legislation. You will all no doubt be fully aware of the Wildlife Transactions and Taxidermy Rules, 1973. But critically, they are also subject to the law of negligence. There is no barber immunity, there's no taxidermist immunity, there's no threshold that overstuffing will only give rise to liability if it's done in bad faith. If you are missing an ear, or indeed missing a family member, there's no question that the law provides full redress. And the very existence of the law of negligence acts as a deterrent and as an incentive for good practice. But ladies and gentlemen, the position is simply fundamentally different in arbitration. For years, we have come together at our ever-increasing numbers of international arbitration conferences, and we have bemoaned the costs and delays in arbitration. We talk about the lack of efficiency, the over-judicialization, the lack of accountability, and legitimacy. We have constituted task forces, we have developed codes, rules, and best practices to improve and optimize the process. And yet we keep having to come back together to complain about delays, about expense, about lack of efficiency. And all this while, there has been an elephant in the room, overstuffed. And the elephant in the room is that a very significant problem that nobody wants to address in terms for fear that it will damage their own career. We all know it, but we don't express it. What is it? Well, in the next few career-shortening moments, I'm going to address it. Without question, a significant part of delay, costs, expense, and lack of efficiency, of redundancy in the process has got nothing to do with counsel, nothing to do with parties, nothing to do with arbitral institutions, bad rules, or national courts and judges, but to arbitrators. There is a long list of misconduct by arbitrators. We all know it. We talk about it privately, but we don't face up to it. I'm going to give you some examples, but before I do, some points of clarification. I'm doing this for now on a no-names basis. The day after I retire, there will be a publication. Secondly, the organizers have checked. Nobody in this room is guilty of what I'm about to talk about. Thirdly, I can guarantee none of this applies in the SIAC. And lastly, nobody before whom I'm currently appearing as counsel is guilty of any of this. Overcharging. Arbitrators regularly and routinely overcharge. When I'm a presiding arbitrator, I'm often astounded with how much time a co-arbitrator has apparently spent when I see the bills, and how little there is to show for it. Clearing the collective pot of funds early on by one arbitrator. Treating the arbitration as a pension fund. Meeting only in the evenings or on weekends, over years. And then, when memories are so faded, having refresher hearings to remind themselves what the case is about. Overtrading. The common business model now is you take every case and you use legal secretaries to actually do the work. Failures to case manage, imbalances in the deliberation process, abuses, failure to actually coordinate with your co-arbitrators, delays in rendering decisions. The list goes on, and we know it. And yet, we continue to live with it. We don't face up to it because we want to keep in the good books of those who will be deciding our client's fate. But the impact is palpable on the process. It impacts directly on fairness, legitimacy, efficiency, and costs. And unlike judges, there's no appeal. There is confidentiality. There is sanctity of deliberations. There is, frankly, an astonishing comparison between the potential impacts of barbers and taxidermists and arbitrators, and the amount to which there are actually controls. Because what are the current controls? We do not have negligence as an action against arbitrators. That takes away a huge area of incentive and disincentive. We cannot have party complaints as the system because we don't complain. We want to be liked by our tribunals. The arbitrators say, shall we charge $500 an hour? And we say, yeah, that's great, no complaint from us, that's fine. $1,000, at what point do we actually speak up? Do we challenge in court? That's a blunt tool, because the fact is, arbitration laws give you very limited recourse as to when you can actually challenge. And what about current codes of conduct? They are piecemeal, and they are limited, and they are generic and anodyne, because they treat arbitrators as a legendary, elevated profession, and so they won't intrude overly. And what about the market? The argument is, let the market decide, but the market is distorted because we have a concept of the mafia. the Mutual Association for International Arbitration. And those are the legendary rock star figures who will get reappointed come what may, because you'll never be criticized for appointing them. So the market doesn't actually count. And indeed, there are those who show their skills at arbitration conferences, for example, in debates, and yet they are incompetent as arbitrators. And there's a mismatch there. You misunderstand somebody for being good at conferences, but actually are they good in practice? And so overall, our current controls are not strong enough. But this is now even more serious than before. The standard response, which you will hear, is don't regulate more, because it will lead to more challenges. It will be a charter for challenges. It will undermine the process. And there are two reasons why that's no longer an answer. Firstly, we cannot keep going in the same way. We can't keep having these conferences talking about the same cost issues, the same delay. Some of us will die in the meantime, and our children will come and talk about the same topics in ever more exotic locations. And secondly, because things have now changed, because arbitrators now are deciding sensitive issues of sovereign discretion. Take investor-state arbitration. Arbitrators are deciding on climate change now. They're deciding on nuclear policy, on pandemic policy, on war. These are issues now in the hands of international arbitrators without actually any accountability. And therefore, we now have to actually rethink. And we have to rethink by having a system which will allow arbitration to continue as robust and optimized and efficient and not overstuffed. Ladies and gentlemen, if we don't act now, then we will have to act, because the process itself will actually fail. And with that, I urge you to support the motion. Thank you.
Thank you, Toby. Some very compelling arguments, I must say. Can I request the next speaker, please? It's actually you. I'm so sorry. I'm sorry. Yeah, sorry. Dr. Singhvi, next.
Honorable judges, distinguished members of this august house, as I rise to speak against the motion, I am struck by how the proponents of the motion are a victim of their own hyperbole. And you've just seen a very good example of that. Plucking out a phrase from Rubin's article based on Rubin's PhD dissertation, the proponents would have this house believe that arbitrators are less regulated than barbers and taxidermists and deserve to be more regulated. But even in 1997, when Rubin wrote that dissertation, that article, arbitrators were definitely less regulated than today. But even then, they were far, far more regulated than taxidermists and barbers. In the last 3 decades, those regulatory regimes have increased manifold. Indeed, even footnote 306 of that Rubin article in California does not cite any regulatory regime, qua taxidermists and barbers. So really you have a proposition, friends, which is frozen in a time warp. Very little true then and far less true now. Turning first to domestic arbitration, especially since the proposition as framed is general without distinguishing between international and domestic. The poor arbitrator is scrutinized for qualifications and disclosure at the inception under our 11.8 by the Supreme Court or the High Court who appoints him. The degree of intrusiveness of sections 12 to 14 is humongous. The language, the width, the degree, the scope of those provisions, and then coupled with the detailing in the 4th to the 7th schedules, makes it clear that arbitrators have to virtually strip naked in terms of disclosures, declarations, and transparency issues, followed by punitive removals, terminations, fee reductions, and general professional and social opprobrium. The proponents should spend more time, some more time at least, reading the 4th schedule fee caps, the hyper-detailed 34 clauses of the 5th schedule regarding independence and impartiality, the fasciculus of disclosures in the 6th schedule, and the further 19 clauses plus 3 explanations regarding relationship with parties and counsel in the 7th schedule. And all this in a parliamentary enactment, not even in the rules. We are talking of regulation, friends, not individual aberrations despite regulations, which is, I think, what the focus of the previous speaker was. Individual aberrations will be there, but are the regulations less? No, we are an over-regulated system. Being a wildlife enthusiast, I have not consulted any taxidermist. But the last time I visited my barber, who incidentally loves me because he saves time and earns more average money in the shortest haircut on my bald pate, he told me that all he needs is a shop license under local municipal law and adherence to some cleanliness norms applicable generally in the market where he operates. He assured me that even the chances of him being sued for a faulty haircut are virtually non-existent, unless he commits a blunder on some Hollywood or Bollywood diva's hairstyle. Nor is he subject to intrusive Section 34 court reviews on his haircut. A review now enlarged considerably by statutory enactments in 2015, 2019, 2021. Nor is he subject to further appellate reviews under Section 37 and followed by the ultimate scrutiny of the Indian Apex Court under our own very special Article 136 of the Indian Constitution. Taxidermists are also quite relaxed because they do not have to keep an eye on strict timelines, which arbitrators must now warily watch under Section 29 capital A on pain of arbitration termination and fee reduction. Foreign arbitrations, though less regulated, are subject to a fairly keen review mechanism of their awards under Sections 48 and 57. And even conciliators, not arbitrators of course, but a form of ADR, have very intrusive limitations in Section 80, which bar their acting as arbitrators, as advisors, as counsel, as representatives in any remotely connected matter. After the very, very recent ONGC judgment, which I had the privilege of arguing, even the residual flexibility of arbitrators in fine-tuning fees for additional workload has been eliminated. I don't know of any similar regulatory bodies or mechanisms for barbers or taxidermists, or for that matter for bakers, butchers, and candlestick makers. And very few were pointed out, except one stray one for taxidermists. In a nutshell, members of this august house, if my karma allows it, and if minimal regulation was my life goal, I would prefer rebirth and afterlife any day as a barber or a taxidermist, and not as an arbitrator. Those of you who are arbitrators, I'm sure, would share that sentiment. Turning, friends, more specifically to international arbitration, the regulatory regime is equally unending. The 1958 New York Convention, we all know, has those 5 well-known supervisory limitations, unable to present the case, dealing with issues beyond scope of arbitration, etc., etc. The UN model law, now adopted in 85 jurisdictions, gives further broadly harmonious supervisory powers to seat courts and seeks to ensure that arbitrators conduct themselves as per party agreement. The rules of arbitral institutions, like yours, like SIAC, play a major role in checking the conduct of arbitration, and that's a further regulatory mechanism. They make it mandatory for the tribunal to ensure efficiency and impartiality, and it's pretty much the same, be it SIAC, Hong Kong, LCIA, ICC, etc. Additionally, parties have increasingly begun to use soft law instruments like the IBA rules of ethics, the guidelines on conflict of interest, the rules of taking evidence. How much more regulation do you want? Under SIAC rules, a party can only nominate an arbitrator. It's the SIAC president who makes the actual appointment, and he has the power to refuse the nominee recommended or nominated. The maximum amount of fees is stipulated and must be accepted in advance. Together, the SIAC rules, the SIAC Code of Ethics, and the practice note, and the SIAC Code of Ethics has to be signed in the beginning, and the practice note stipulates stringent disclosure requirements. They set out efficient procedure for deciding challenges. Financial management is separated from the conduct of proceedings. The registrar has the power to determine the actual costs of arbitration, including the fees, at the conclusion of the hearings. This translates to fee implications for arbitrators who do not conduct arbitration in an efficient and fair manner. The President can also step in and conduct a case management hearing in the event of inefficiencies. Sadly, the proponents have hardly been able to point to any similar, analogous, comprehensive, intrusive regulatory mechanism for taxidermists and barbers. Friends, the proponents also commit the cardinal sin, and it is a cardinal sin, of devaluing and decimating party autonomy. International arbitration is built on the bedrock of that party autonomy. My good and wise friend Gary Bourne rightly put it. Moreover, the single most fundamental theme of international arbitration generally and the selection of arbitrators specifically has been the party's autonomy. Imposing licensing and regulatory requirements on the party's autonomy would run counter to this historic, deeply rooted objective of the arbitral process. It would also threaten to confer a quasi-monopoly on a particular subset of arbitrators, in a sense, ironically, the same mafia we heard about, shielding them from external competition, which is an important element of quality control. The right to appoint arbitrators, even multiple appointments, is a key characteristic of international arbitration. Wilson Coe puts it accurately when he says, even if it is true that concerns over the legitimacy of arbitration have increased, to address them by restricting a party's right to appoint arbitrators would be akin to curing the disease by killing the patient. Bourne has accurately prophesied, something which I've agreed with him earlier. In the worst case, licensing requirements would be a backdoor means, and that is what this debate is about. That is what this proposition is about. That is what the proponents want this House to pass and vote in favor of. In the worst case, licensing requirements would be a backdoor means for re-rationalization and denutralization. Is this what they want? If they do not want it, please remember, the path to hell is often paved with good intentions. Thank you very much.
Thank you, Dr. Singhvi. Now, Ms. Pallavi Shroff, arguing for the motion. Thank you.
Good evening, everyone. Respected judges, my colleagues on the dais and friends. A very interesting topic with different perspectives. Well, we've spoken a lot about taxidermists and barbers, and we all hope to find the best barber that we want, whether he is regulated or not. And I don't think, at least my barber, my hairdresser is regulated by any laws. But that doesn't mean that we don't go for the best and we don't put together the highest standards for the people we select. I think this proposition is relevant today as it was relevant when the thesis was written. What do we face today? We have huge arbitrations, big and small, complex arbitrations, arbitrations that affect the lives of several people, and we have absolutely no minimum qualifications that are prescribed in our law. And I'm going to speak more on in the Indian law. No qualifications are prescribed as to who can be an arbitrator. There is no code of conduct or ethics for arbitrators under Indian law. What we have imported are the schedules from the IBA, but those are conflict of interest rules. They are not qualifications or code of ethics. And what we see is that there's absolutely no consequence for any misbehavior or irregular conduct of a process by the arbitrator. So today, what do we here see in India? Most of the arbitrations, or a large percentage of arbitrations, are actually ad hoc arbitrations. They're not institutional arbitrations. With institutional arbitrations, certainly there are a lot of benefits. You have a panel of qualified lawyers you can select from, procedural framework, timelines are prescribed, there's a schedule of fees, time periods for various activities, scrutiny of awards, all of them there is a regulated framework. With ad hoc arbitrations, there is no framework. Well, it may be said that we now have a timeline to be prescribed under the law, but that's a broad timeline. How do we manage the timeline? Do we go back for extensions? that is still a problem. We've seen even the extensions have taken enough and more time. Having said that, all the ills that Toby has mentioned are still at large. We see overcharging. You have evenings and weekends. There is no real arbitration bar that we are seeing. And because the arbitrators themselves they're so busy, they're doing 3 arbitrations in a day. You see that a lawyer still has his code of conduct and ethics and is regulated by the Bar Council. You have equally a Chartered Accountants Association. You have a Company Secretary Association, medical professions, but there is absolutely nothing, no body that actually regulates, governs, or even oversees the conduct of an arbitration. So let's not confuse the 5th and the 7th schedule with the qualifications that are prescribed. The government did try to bring in the 8th schedule, but before it was brought in, it was withdrawn because of some ambiguities. Instead of removing the ambiguities, amending it, they just chose to withdraw. So we are still in the same position. Anybody can be appointed, whether they may be actually qualified to be an arbitrator or not. As we move forward, we see that even if the award is given by an arbitrator who is not a lawyer, doesn't have a judicial thinking, or doesn't even have a judicial approach, because you are adjudicating rights between the parties, it doesn't matter. Even a layperson, the Supreme Court has said in Associated Builders, that it's fine. Even if he's not trained in law, award cannot be set aside. Also, let's see what happens. As Toby said, taxidermists and barbers may be subject to law of negligence. But as far as arbitrators are concerned, there is a protection. Anything done in good faith cannot be called to question, and the arbitrator is actually protected. So, and the only exception, even when you come to challenge of an award, is if there is fraud or corruption. You assume that you prove fraud or corruption in some form when the award comes to challenge. The award is set aside. Is the arbitrator punished? No. The arbitrator is not even commented upon in most cases, or nor is he criticized, and the courts let this go scot-free. There are no penal consequences upon the arbitrator who may have actually perpetrated fraud. When we say, why is all this required? You have chosen a forum as an alternate forum to the judicial system of that country to adjudicate your disputes. We all respect party autonomy. We all respect the basic tenets of arbitration, but the arbitrator does do justice. He's required to follow basic principles and do justice. Justice must not only be done, but must be seen to be done, and some form of code of conduct and regulation is therefore quite called for. When you see discharge of powers by an arbitrator, it comes only at the end of the day. Who suffers? The parties suffer, but not the arbitrator. Arbitrators most often are judges, and with some exceptions that we all know, judges start at 10:30 to 1, 2 to 4, because 5 o'clock there is another arbitration that's happening. I think when will we see a stricter sort of a discipline? I'm not even saying regulation. Why can't we have arbitrations that start at 9:30 in the morning, finish at 5 in the evening, and continue on a day-to-day basis till the arbitration is complete? The conduct of how the arbitration is conducted is equally important. The CPC does not apply, and the Evidence Act does not apply. But you will come across arbitrations where the members of the panel will sit, and for 5 days, the traditional way of proving evidence is allowed to go on, where they will say, the counsel says, I put to you so-and-so, so-and-so, putting his case. The other party says, no, I don't agree. And that's all recorded for the next 3 to 4 days. Conduct and the discipline with which arbitrators conduct so that they don't go on and on is as important. For all of these things, I think it's very important that there is some form of code of ethics, some form of regulation for the arbitrators, so that arbitrators, actually the process of arbitration and the integrity of the process of arbitration is upheld. Thank you.
Thank you so much, ma'am, for those valuable insights. And thank you also for sticking to the time. And may I remind the other participants to please stick to the time. I've just been passed a note here which says that, if you exceed the time, there's going to be negative marking. So please.
Thank you. I like how that warning has come just before the last participant, but I will stay with my time. Ladies and gentlemen, I want us all to spare a thought, as Dr. Singhvi did, for Richard Rubin. He was a doctoral student in 1997, perhaps struggling to write that third dissertation paper to get his doctorate, and perhaps struggling for something novel and eye-catching to say, and then he finally found it. Barbers and taxidermists are subject to far greater regulation than arbitrators, he pronounced. No footnote regarding the regulation of taxidermists, as Dr. Singhvi says, but his footnote was that only some states in the United States require arbitrators to take an oath of fairness and impartiality as a condition of their appointment. How far removed from today's arbitration world? I dare say in 1997, if Richard Rubin had heard that his dissertation paper would be the subject of a debate with leading academic practitioners like Mr. Landau and Mr. Shroff, and with an arbitral institution like SIAC, he would have been more than chuffed. But I did some research on Richard Rubin. A quarter of a century later, he's now a leading academic at the Missouri Law School, and he describes himself as one of the nation's leading authorities on confidentiality in ADR processes. The idea of confidentiality, as you can well imagine, does not really sit well with the idea of regulation. Far from being chuffed, ladies and gentlemen, today he would be mortified that his doctoral dissertation, perhaps his youthful indiscretion, has now been turned into a debate topic by SIAC. I dare say he would not defend the motion with the same vigor that Mr. Landau and Mr. Shroff have. But this is what happens, ladies and gentlemen, when you pluck an idea shorn of its geographical and temporal context and introduce it to modern-day arbitration. And that's particularly true when the geography is the United States and the time is 1997. A little bit about my last haircut, ladies and gentlemen, before I dive into what you all have come to hear. Excruciating details about Section 11, Section 29, the fifth schedule, Part 1A of our Arbitration Act. My barber is annoyed with me. My normal haircut is full of conversation, gossip really, about what my friends and colleagues at the bar are up to. My last haircut, though, I want you to know about his qualifications and the laws that regulated him. He was offended and concerned in equal measure. But through that rigorous research, I came to oppose this motion even more strongly. The oversight and regulation of arbitration is all-pervasive. From immediately before their appointment until after delivery of their award, the arbitrators are regulated. Let me make that good. Let's start, ladies and gentlemen, with the issue closest to this audience of commercial dispute lawyers, money. Unlike barbers and thankfully counsel, arbitrators' fees are indeed regulated. Far from being prohibitively expensive, as Mr. Landau would have you believe, appear as an arbitrator or act as an arbitrator in any international institutional arbitration, your fees are regulated based on the value of the claim and largely divorced from the time you spend. Notwithstanding the essentiality of a barber's services, their fees are not regulated, nor under the Essential Services Act. And in India, we've gone a step further. We have a cap on fees. I dare say, again, far from Mr. Landau's understanding of overcharging arbitrators, in India, we are making arbitration prohibitively inexpensive. Then we come to time. I understand arbitrators need to act with some measure of dispatch, and if you look at institutions, they nudge arbitrators to act quickly. But another example of how far regulation can go, we have Section 29A. Imagine, ladies and gentlemen, if I walked into my barber's hairdressing salon and said, you have 12 minutes to give me a haircut. I can allow you 6 minutes more, but if we take any longer, we'll have to go to a court or a council for approval. And ladies and gentlemen, the regulation of arbitrators does not stop at time and money. In the first instance, there are strong checks on who and who cannot be appointed as arbitrator. Dr. Singhvi has read out to you the item numbers in these various schedules. I don't want to repeat them. But, ladies and gentlemen, we regulate who can arbitrate, for how much he can arbitrate, for how long he can arbitrate, and then we tell them how to arbitrate. The conduct of arbitration is also regulated, and a failure to follow due process renders an award liable to be set aside. My final point on regulation is the scrutiny that an award goes through and the setting aside process that offers a good check on an arbitrator. Perhaps my experience as a young arbitrator is different from yours, but my awards are scrutinized quite intensely by institutions. And then, as I said, in addition to the scrutiny, there is the threat of the award being set aside. Contrast that with barbers, ladies and gentlemen. Have you ever heard of a haircut being reversed? A bad haircut, as I have learned, can only be fixed with prayer and time. I hope we've established that this motion must fail, and that arbitrators are already subject to far greater regulation than barbers, but I want to go 2 steps further. I want to persuade this House that the idea of greater regulation of arbitrators is itself misplaced. The whole purpose of arbitration is an escape from the regulated traditional justice delivery system, and to allow parties autonomy in the manner in which they wish to resolve their dispute. We already limit what matters are arbitrable, and various are not. Today's regulation already extends beyond what it should, and we must draw the line at this at least. And I add this note of caution because the call to greater regulation is a call to a slippery slope that we do not want to get to. In the late 1990s, when I was a graduate law student in the United States, I contested the misconception that India was a land of snake charmers. I used to tell my friends that India was really a land of regulators. We loved, and sadly still love, nothing more than to regulate what is regulatable. And nothing, ladies and gentlemen, is more regulatable than something which is thriving. Enter arbitration in India in 2022. You have a glimpse, ladies and gentlemen, of the regulations my opponents today seek in Part 1 of our Arbitration Act. Carefully sneaked in between in Part 1A. It's carefully sneaked in between Part 1, which seeks to promote arbitration in India, and Part 2, which seeks to assist in the enforcement of foreign awards. Enacted in 2019, Part 1A is waiting to be notified if motions like today succeed. It contemplates, ladies and gentlemen, the establishment of an arbitration promotion council. Don't get misled by the term. When something says promotion council, you know what it's all about. And this arbitration promotion council, comprising largely government appointees, will oversee the process of accreditation of arbitrators, grading of arbitral institutions, and it will maintain a depository of awards. The gradation of institutions will determine which institutions can act as appointing authorities. While the public law lawyer in me salivates at the litigation that this will generate, I don't think any one of us in this room, including Mr. Landau and Ms. Schroff, want to see government intervention of this nature. And the final point, ladies and gentlemen, even if we decide we need more regulation, we need to address ourselves to who will regulate. Which state, in a matter where there is an international commercial arbitration with so many stakeholders, which state will regulate? My obsession with my hair and with arbitration law and practice has left me no time to do a point-by-point comparison with the taxidermist regulations. So let me say only this. In my research, I came across a 2016 article in The Hindu, which says that one gentleman named Santosh Gaikwad is the only person in Maharashtra who is authorized by the government to stuff wild animals, and that he often uses his freezer at his house to keep stuffed birds. That certainly doesn't conjure up an image of a very tightly regulated industry. I'll leave for another day, ladies and gentlemen, the issue of whether we even want to borrow the model of regulation from the shrinking field of taxidermists. I want to end as I began, with Richard Rubin. His article is wonderfully academic. He acknowledges, and I quote, that he leaves for another day the important issues of how to integrate constitutional norms in the seemingly private process of arbitration without sacrificing the very virtue of these processes. I urge you, ladies and gentlemen, what Richard Rubin left for another day, let us too leave for another day. Arbitrators are already more than sufficiently regulated. Let us vote against this motion that seeks to undermine, indeed sabotage, the very gains made by arbitration world over since 1997. Thank you very much.
Thank you so much, Mr. Ritin. Now for the interesting part. Now is the part where you get to rebut each other. So can I call upon one speaker from the...
Ladies and gentlemen, in Cambridge, there is a park called Parker's Peace. And there is a crisscross of paths. And in the middle of that crisscross, there is a big lamppost. And that lamppost is called Reality Checkpoint. I want to bring you all to Reality Checkpoint. We are told that since 1997, there has been a great change because now there is lots of regulation. We are told that the regulation is in various sections of the Indian Act, it's in the New York Convention, it's in the model law, that arbitrators now are stripped naked, figuratively, I hope, otherwise this is too disturbing to cope with, in terms of disclosure. And we're told that all is well. Ladies and gentlemen, here's our reality checkpoint. Is all well? If all was really well, why are we meeting all the time and talking about delay and inefficiency and what do we do? It's all expensive and there's redundancy and this is not what we contracted for. We cannot keep doing this. We can't keep meeting and talking about the same topics. We will only solve this if we actually grab the issue as we need to grab it. And that is uncomfortable for those who don't want to be regulated. Anybody who doesn't want to be regulated shouldn't be an arbitrator. Ultimately, the current tools are not enough. We know it by the evidence itself. I don't need to justify it. Even when one looks beyond Indian law, if one looks beyond institutional arbitration, which is really the meat of what's being put against us, and look to ad hoc arbitration, where are the controls? You can't control somebody overcharging by asking to set aside an award under a national law, or seeking to resist recognition and enforcement under Article 5 of the New York Convention. That doesn't solve overcharging by one arbitrator. That doesn't solve evening hearings and excessive delay, because those aren't sufficient grounds for setting aside an award properly. And so let's move on. What about party autonomy? Why is this an attack on party autonomy? Who is contracting for an overly expensive, inefficient arbitration? Nobody. We are promoting party autonomy. What we're doing is building into the process a mechanism to realize the contractual objectives, which is something which is actually a more attractive system of dispute resolution than court. That can't be an attack on party autonomy. It depends upon contracting into the regulation. And that's, of course, what one would do if one had a proper system for it. And then we had a cri de coeur for the poor arbitrators who are burdened. Poor things. They've got to disclose lots. Let's just put this in context. RWE and the Netherlands is a current investor-state case where there are 3 arbitrators. They will have to decide whether the Netherlands policy for climate control, that is, stopping coal producers from continuing, is lawful. Their decision is going to impact on climate change for the whole of the Netherlands population. Tetian and Pakistan, 3 arbitrators who have rendered an award against the state of Pakistan for $7 billion. That is a huge proportion of the whole national budget. That might stop the government from actually putting money into healthcare. Are we worried about these arbitrators giving some disclosure? Worried about monitoring them? We've moved away, I'm afraid, ladies and gentlemen, from the old story of simple contract arbitration. This is an incredibly powerful process, and any powerful process requires naturally some accountability. It requires some transparency. And ultimately, what are the dangers that are put against this? The dangers, I'm afraid, are too vague to be meaningful. We're not talking about the problem of government interference. We're not talking about any interference as such. We're simply talking about shoring up our current system through contract and agreement with more tightly controlled rules and regulations with teeth, so that parties can go into the process with confidence, with accountability, with transparency where that's needed, and legitimacy. And what are we doing ultimately? What we're actually doing, apart from curtailing the whole story of international conferences, what we're doing is preserving the process that we all treasure in what is a very new and demanding environment. And so far, we have simply failed to do. Ladies and gentlemen, you know what to do. Thank you.
Thank you, Mr. Landau. Now, rebuttals from the side against the motion. Dr. Singhvi leading the rebuttal for the side against the motion, ladies and gentlemen. Thank you.
I heard with growing alarm, and I hope so did you, a possible case for allowing arbitrators to be sued for negligence. Is that what you heard? Is that what I heard? I think the bedrock of the adjudicatory system, be it in courts or in arbitration, where you have to decide against one person, is not to allow suing in negligence. Are they to be allowed to be sued in negligence as, for example, a barber or a taxidermist for a bad cut or for bad overstuffing, which of course usually he is not sued for? I think that would be the beginning of the end of the entire concept of arbitration, indeed of adjudication. It would strike at the very root of something on which the system is based, which is protection for work done bona fide. And I think my friends, in their zeal for proposing the proposition and promoting it, are really striking at the root of the entire system. We then heard laments, two principal ones: high fees, evening sittings. Do you think that is really a result of under-regulation? Do you think more regulations will change that? Thou shalt sit at 10:30 and thou shalt not charge high fees. Today, by the way, as far as fees are concerned, people believe, and that feeling may be growing after the ONGC judgment, that the fourth schedule and the ONGC judgment combine to make, as my friend put it, arbitration prohibitively inexpensive and not attractive at all for lawyers and for arbitrators. But certainly, runaway fees, uncontrolled fees, unknown fees, uncanalized fees, that is not the landscape. There is already so much of regulation on fees. And now the judgment, I fortunately was able to save international arbitration from the Essential Commodities Act approach of the Supreme Court in the ONGC judgment. Otherwise, there might have been caps even there. So what are we talking about uncontrolled fees? Evening sittings. I think ultimately this is a marketplace where if you don't perform, you perish. A lawyer who is consistently known for his defaults is not going to succeed in the profession, and an arbitrator who is known over time for not doing his job efficiently, properly, or for wasting time, the marketplace will turn him out, not a regulation. Today, 29A means precisely the 4 o'clock, 5 o'clock syndrome. How do you complete an arbitration in 1 year? How do you avoid the extension, the scrutiny of the court, the opprobrium, the loss of reputation in the arbitration sector? I think these are things best left to the marketplace. People know much more than you think. You don't have to give them a regulation to understand who is an efficient and a good arbitrator. Actually, if at all, we are a case of over-legislation or over-regulation, maybe under-enforcement. But under-enforcement and over-regulation are two very different things. We have a proposition which this House must reject, which seeks over-regulation and more than over-regulation. In that process, it seeks to create a bureaucracy which in its wake, to use the words of Bourne, may lead to incipient nationalization of this sector by committees, by regulations, by additional scrutinies, by intrusiveness, and that is something which lies at the heart of this proposition, which I beseech this House to reject. Thank you.
Thank you very much, Dr. Singhvi. Excellent submissions by both the parties. I think that deserves a round of applause. So we're going to take a couple of questions from the audience. Please keep it very, very brief and short. Please don't state your opinion. If it is a question, please ask. And please also do not share your experience with barbers or taxidermists. We do not want to know that. Can we just have a couple of questions from the audience, please?
Yes.
Good evening. My name is Ashik Karim. I'm a student of law from Nalsar. My question is to Dr. Abhishek Singhvi. Sir, I was convinced by your domestic arbitration argument, but with regards to international arbitration, my question is with regards to party autonomy. So you spoke about how you cited Gary Bond to suggest that regulation goes against party autonomy, which is the bedrock of arbitration and on which it is built. But isn't party autonomy a concept which is to be understood as mutual consent and agreement? Now, on this front, I would like to refer to Ms. Sheila Ahuja's experience with another international arbitration institution, wherein she pointed out that when there was an obvious conflict of interest with the arbitrator, their challenge did not stand because there was no regulation on that front. Although you cited SIAC rules and explained how SIAC rules can ensure fairness in terms of appointment as such, do you still believe that the New Convention's 5 limitations and soft law instruments such as the IBA rules of ethics for international arbitrators is enough in the international arbitration front? That is my question.
Well, in the specific context of misconduct or conflict of interest, the answer to your question is yes, an emphatic yes. There is no gap left. I don't know of any reasonably reputable arbitral chamber with detailed rules which do not police conflict of interest and misconduct well enough. Remotest conflicts of interest are looked at. Domestic arbitration, the conflict of interest clauses in our Act, I could not believe the detail at which an Act of Parliament can go. You have to stop reading after a while because they are far too detailed. Now, if somebody escapes through that, that's not a case for additional regulation. It's a case of working out policing. So, conflict of interest, which is the heart of your question, I would say there is ample scope in the arbitral chamber rules, in the domestic acts, in all the fasciculus of code of ethics and so many other things we have, the practice code, to cover everything. And remember one more thing in international arbitration with which you started. International arbitration ultimately will not be controlled by an international treaty. You won't have an international treaty which is a supranational international criminal court sitting and regulating arbitrators. They'll have to rely either on the arbitral chamber rules, which we've all cited, and to which I don't think there's been a full answer on the proponent side, and alternatively in the national legislation. Where else will this regulation come from? Unless somebody is suggesting an international treaty on regulation of arbitrators.
Thank you very much. Looks like Toby is rushing for the mic. So.
No rushing. I'm perfectly calm, relaxed. This one? I'm going to answer the question differently. It's not enough. I think the organisers are sabotaging one side of the argument. The answer is no, it's not enough. And we know it's not enough because already the consensus is it's not enough. And that's why we've already got new draft codes of conduct which are in play. ICSID and UNCITRAL have very recently published a new kind of code of conduct in recognition that the current structure is just inadequate. So actually the answer, the consensus in the arbitration world is we do not have enough at the moment. This isn't just about sitting hours. It's not just about overcharging. It's about very fundamental issues of honesty amongst arbitrators, about their conduct, which at the moment is not being caught by challenges that were thought about in 1985 when the model law was drafted. And let me just say this, the marketplace itself is uneven. Information is not evenly spread. It's not fair internationally to say the market will decide, because somebody who is facing an arbitration claim in a country with little experience in arbitration may not know the market. And so that is actually, in a sense, quite a dangerous answer to this, because all it does is it perpetuates those who have already built a reputation. And so coming back to the point, the gaps that are there are actually now of concern. They don't need to be filled by government treaties or by regulations being imposed without consent. They can be treated very simply. They can be solved very simply, which is, for example, an international instrument rather like the UNCITRAL rules, which gets contracted into by parties where there is no institution, ad hoc. They contract into it and thereby bring into their process, through party autonomy, high standards and proper regulation.
I think we have time for another quick one.
Hi, Ganesh Chandru. May I? I have a question for Ritin. See, on qualifications of arbitrators, it's the entire arbitral process is so flexible that even a barber or taxidermist can be an arbitrator, right? Forget their regulation, they can also act as an arbitrator. But don't you think there has to be some, I mean, of course there was a talk about Schedule 8 and it was removed, and the Arbitration Council of India, if it is notified, has powers to make regulation. But internationally, don't you think there has to be some kind of standard or some kind of a basic qualification for somebody to decide a case? Because it's going to be final and binding. They're almost like judges in a private setting.
Look, I think that's a fair question. I was also concerned when Toby said the organizer trying to sabotage things. Be careful, there's a suit for negligence coming up soon. Ganesh, to answer your question, I think the fundamental idea of arbitration is you get to choose your judge. And like you said, a barber can be an arbitrator, a taxidermist can be an arbitrator, a construction person can be an arbitrator. So fundamentally, qualification of an arbitrator can only be housed in an arbitration agreement. Please pick your judge in your arbitration agreement. And please, if you have no faith in the arbitration system, as Toby's giving us examples, please don't pick arbitration. If you think it's an uneven fight with a player who has better information about that system, please don't pick it. But please let us not try and intervene in this market. When people understand what they're doing and they want to consent to arbitration, please let us not distort that by regulatory interventions. Thank you.
I think now it's time for the verdict. The judges may deliberate and then announce the results, and any thoughts or comments by the honorable judges. Thank you. So while the judges deliberate, what's the sense of the audience, the popular award, if we may? I'm so sorry. Just let them know, decide, and maybe we'll announce that later.
No? All right. So, between the two stands taken, the extreme stands taken on either side, I believe that the truth lies somewhere in the middle. The first point, which I feel does certainly require regulation, and I think in the Indian context particularly, setting timelines by the statute has worked extremely well in our jurisdiction. In fact, a lot of foreign arbitrators told me when I was actually a part of the committee, the Sri Krishna committee, which had brought in the amendments of 2019, and representations were made by various organizations, including SIAC, that please don't control our timeline, we do it. So we had made that more flexible. But I think timelines are very useful for the disposal of proceedings and to get an award in your hand within a period of 18 months or maybe another 6 months. That happens now, and I think that regulation is particularly helpful. The second area where I feel regulation is necessary, because that is the fundamental basis of arbitration, that there must be fair adjudication by a neutral arbitrator, is in the area of conflict of interest. And I would not agree with Dr. Singhvi where he feels we are over-regulated. We have come across cases where arbitrators have been appointed by certain organizations repetitively, 74 times, 80 times, and you know what, it's a foregone conclusion. So some regulation is required. In India, we have taken the IBA guidelines and given, we entered them into the schedule to the Act. It has got a statutory flavor, and I think it is much better now. The only aspect is where Dr. Singhvi would disagree, but I think that the declarations, merely making declarations is not sufficient. There has to be some consequence to it. Otherwise, I have known arbitrators who refused to give honest declarations. It became very problematic and the matters came to court. So certain amount of regulation, particularly with respect to timelines, secondly with respect to conflict of interest, are certainly necessary, and I think they have worked well in our jurisdiction. Thirdly, even with respect to conflict of interest, I feel that the disclosures are not required to be made only by the arbitrators, but also today we see a lot of third-party funding. So that also should be disclosed so that if there's any conflict of interest, that can be taken care of, because we know the amounts today which are involved in arbitrations. With respect to the, Mrs. Shroff had said that arbitrators are doing 3 arbitrations in a day, etc. I would not agree with her. Suppose you have a CMC hearing in the morning, which is a case management conference. Certainly you are entitled, you have the freedom to fix another hearing through the day. There's nothing wrong with it. We are not doing anything unethical. And I think that is a part of our profession, how we manage our time, provided we give the award within the timelines which have been set by the statute. That freedom we must always have. Secondly, about evening arbitrations, I do want to comment that there are, I'll tell you from my personal experience that evening arbitrations are done at the request of counsel, particularly PSUs who are busy in the daytime and do not have time, and they want to come in the evening, and we accommodate them because we also want to have a proper schedule of time. We don't want to be working late hours in the evening and on Sundays, which most of us refuse to do. But when we do it at the request of counsel. And for that, a proper arbitration bar is required. That is actually the answer, and not blaming the arbitrators. Thirdly, with respect to tribunal secretaries, delegation, Mr. Toby Landau said that arbitrators delegated. I don't think the responsible, mature arbitrators do that. We are mindful of our responsibilities, and I think it is very necessary. From my personal experience, I have appointed tribunal secretaries in every single arbitration where I have been appointed the chair. And if I'm not, because in 85% of my cases, I am either the chair or a sole arbitrator, and I think it works well. They are helpful in doing research, etc., which helps streamline the process. So I really feel that the truth lies somewhere in the middle. If one can't take an extreme stand on either side, certain amount of regulation is necessary. In India, it's been done through statute. It can be done through the institutions. Of course, the truth is that the bulk of arbitrations in our country is ad hoc. So therefore, it can be done through either agreements, and of course, now we have the Act. But of course, I'm not for further regulation apart from what is in our statute. Lastly, on the point of investment treaty arbitrations, I think time has come that the confidentiality part must be done away with, because it impacts on the people, the citizens of a country, the taxpayers made liable for any defaults. So confidentiality should go out of the window insofar as investment treaty and arbitrations are concerned. There needs to be far greater transparency, and you can't have confidentiality in these proceedings.
I hope that this time's up is not for me. Anyway, since this is a debate and it is supposed to have been what the House thinks, not what the judges think, right? So we should have put it to the House to vote. But I don't think we'll do that because we'll have a lot of conflict on that. Insofar as us as judges are concerned, it is difficult. It's a difficult topic to judge because we are also being judged in this debate. You see, it's the arbitrators who are on the dock, and we as arbitrators are to judge whether arbitrators need regulation or don't need regulation. So isn't there a conflict of interest in this itself? Isn't there a bias in this itself? And therefore, if I say, or if we say that there shouldn't be any further regulation, there is already some regulation, then we may be termed as being biased. And if we speak on the other side, then it harms us in any event. So it's a difficult choice, but insofar as the content of the debate is concerned, I think both sides have argued their points of view very well, except that on both sides, maybe Dr. Singhvi touched upon it, both sides never talked about the role of counsel. Unfortunately, arbitration is done not just by arbitrators, but by counsel. So what is the contribution of counsel to delay? What is the contribution of counsel to evening hearings? What is the contribution of counsel to adjournments? What is the contribution of counsel to any kind of conflict in the sense that every little application, every little matter is being disputed upon? And of course, in India, domestically, we have appeals going on from interlocutory orders, which tend to delay things. Nobody has talked about that. But ultimately, as we decided, it was a difficult choice to decide as to whether there should be regulation or there should not be any regulation. Certain areas, yes, they should be regulated. But I think that since it is essentially arbitration is an alternate to the court system, where you file a suit in the court and you are placed before some judge, not of your choice. And arbitration is a choice of parties. You choose your judge, you choose your arbitrator. So where is the question of qualifications or regulations for qualifications of an arbitrator? There may be two warring parties having disputes, and they may have faith and confidence in somebody who's uneducated. He may arbitrate. He may give a decision which is just and fair without him knowing all the niceties of law. Is it necessary? Sometimes there are these huge technical contracts where we judges find it difficult, whereas what you need is a technical person who may be able in a better position to decide. So I don't think that there can be any regulation on qualifications of judges. As it is in the domestic arena, there is enough of disclosure. Of course, if there are difficulties in the sense that, as Dr. Singhvi pointed out, I think the case for regulations is mostly based on individual aberrations. And if there are individual aberrations, in the case of a barber or of a taxidermist, of course, deals with dead meat, whereas a barber deals with hair which grows again. So it's a completely different fields of operation of arbitrators and barbers and taxidermists, and I don't think that's a fair comparison to make at all. But the only thing is, the substance of the matter is whether there should be more regulation or what is there is enough. Of course, there are delays. Of course, there are some arbitrators are charging very high fees. But there are, in India, in the domestic scene, there is a cap on arbitrators' fees, and nobody is looking at the counsel fees. So I think everything has to be looked at in a holistic manner and balanced, and see what is the cost to the client. The cost to the client is not just the arbitrator's fees, but is also the fees of the counsel. As you have the concept of cost to company. When you engage somebody in a company, a new person is employed, it's cost to company. You give him a car, you give him a house, you give him a membership in a golf course, etc. So what's the cost to the company? So cost to the client is not just the arbitrator's fees, but the cost of counsel, cost of the firm, which are also overcharging like anything. And senior counsel, etc. I don't grudge them. It's their time. People want to pay for it, go ahead. But you can't grudge arbitrators also, it's their time. They, in that sense. So, therefore I think, yes, we ultimately decided that let the decision be left hanging in the middle somewhere. It's best for us, despite Toby's disclaimers in the beginning and the Parker's piece checkpoint.
So it looks like the matter has to be referred to a larger bench. And the larger bench is right here. So can we have a show of hands as to how many of you vote for the motion, which is to say there has to be more regulation? Okay. What about against the motion? Okay. So I think... Thank you so much, everyone. You've been a wonderful audience. Thank you so much to the panelists, respected judges. It's not every day that we get to hear such distinguished people on the stage. I, for sure, and I echo Bharat's sentiments as well. We've got a first-class seat to witness all of this firsthand. So thank you so much. It was a great learning for all of us. Thank you very much.
With that, we're coming to the end of today's event. I invite Mr. Rajiv Luthra, member of the SIAC Board of Directors, founding and managing partner of Luthra and Luthra Law Offices, for the closing remarks.
Ladyship, my lords, my chairman is not here, my seniors, ladies and gentlemen, we have come to an end what has been a very productive and enriching discourse centered around the contemporary challenges and issues in international arbitration space. But I have taken leave of the court. Both the judges have allowed me to announce an award for the split judgment. Both Toby and my dear friend Manu Singhvi will be taking 2 cases pro bono. Please line up quickly. It's first in and first pro bono. I had written a whole lot of things, but since we are running out of time, I just say 2 things very quickly to come to my heart. One is today was actually brilliant. We got real enthusiasm, real bottom of the socks type of discussions. Wonderful. Kevin, is he here? Right there. So he talked about India being an international arbitration setup. And he asked my colleague Krish, let me quickly give you my thoughts, sir. India is the only country in the world, time zone wise, we can talk to Tokyo and talk to New York during our office hours. No other country you can do that. Second, we have a fabulous airport at Delhi Airport with 200 acres of empty land around it, with 9 hotels of every star possible already built. Think, if we got our act together, think if SIAC came and ran that center. Think if Maxwell Chambers, who have all the facilities and the knowledge and the technology, just came and set it all up. In fact, this idea came to my mind a few years ago when young Gary Bourne had come to India, and I actually went with him to meet ma'am at her chamber at that time, and a few others, and we also went to meet the then Law Minister, Mr. Ravi Shankar Prasad. And I kept saying, and I took GM Rao, the owner, part owner of the airport, with me, who's also a client. I said, let's get 3 buildings. One, an arbitration center, which will be run at least till we get our act together by SIAC. Second, Maxwell Chamber type facility. Another part in that building. One building for the bar, the so-called arbitration bar, which doesn't exist, pure. So GM Rao, when I kept saying this, he says, you wanted 3 buildings. I said, third is for me, for the idea. Of course, we are still where we are. Longest discussion, but I would urge the government of Singapore and SIAC and the government of India to get their act together. This needs to happen, and we are right there. So let me conclude today by requesting all the organizers that every time they hear much ado about nothing or no further ado, I should get $1. So let me make $1. Without further ado, let's get to the drinks. Good evening.